So yesterday we talked about misrepresentation as one of the vitiating factors. And today I want us to look at mistake in contract law. So what is a mistake? A mistake is a wrong belief about a fact when entering a contract. Now, it's interesting to note that there are two types of mistakes. We have mistake of law and we have mistake of fact. So, first and foremost, I want us to look at mistake of law. So, as a general rule, mistake of law does not affect a contract. And the reason why mistake of law does not affect a contract is because ignorance of the law is not a defense. But there are certain exceptions where a mistake of law may affect a contract. And the exception is where you have a mistake of foreign law. So a mistake of foreign law may actually affect a contract. The second type of mistake is a mistake of fact. We call these operative mistakes. So mistake of fact can actually affect a contract. Now, there are 5 types of mistakes of fact. The first one is a common mistake. The second one is a mutual mistake. The third one is a unilateral mistake. The fourth one is mistake as to quality of subject matter. And the fifth one is mistake as to document signed. So I want us to look at the first one, which is a common mistake. So a common mistake occurs when both parties make the same mistake about an important fact involving the contract. Now, the effect of a common mistake is that it makes a contract void. Now, remember, when we say a contract is void, it simply means it is invalid from the beginning, or it is a nullity from the beginning. So there are 2 types of common mistakes. The first one is res extincta, and the second one is res sua. So I want us to look at res extincta. So res extincta simply means the subject matter does not exist. And a good example is where you have goods which have been destroyed before a contract. Now, if you look at Section 8 of the Sale of Goods Act, it provides that where there is a contract for the sale of specific goods which without the seller's knowledge have perished, then the contract is void. And here we have the case of Coturia versus Hasty. And the facts of this case were that parties entered into a contract for sale of corn which was believed to be in transit. But corn had already been sold earlier due to spoilage. And the issue in this case was whether the contract was valid. And the rule was that if the subject matter does not exist, then the contract is void. The application of this case was that the corn no longer existed at the time of the contract. So the conclusion of the case was that the contract was void for common mistake. A similar holding was made in the case of Lacey Anderson versus Valabdos Halidas. And the facts of this case were that parties entered into a contract for the sale of gunny bags. Now, unknown to both parties, bags had already been destroyed by fire. So the issue in this case was whether the contract was enforceable. And the rule was that contract is void if the subject matter does not exist. And the application of this case was that goods had already been destroyed by fire. So the court concluded that the contract was void. Now remember, I've said when we say the contract is void, we simply means it is invalid from the beginning, or it is a nullity from the beginning. Now, the second type of common mistake is res sua. Now, res sua occurs when buyer already legally owns the property. So that the effect of res sua is that it makes the contract void It makes the contract invalid from the beginning. It makes a contract a nullity from the beginning. And a good example is, let's say person A enters into a contract to buy a car from person B. Yet both A and B could be unaware of the fact that person A is actually the legal owner of that particular car. So that the purported seller in this particular scenario has no title to pass, hence the purported contract is void, it is invalid, it is a nullity. And here we have the case of Bingham versus Bingham. And the facts of this case were that a person entered into a contract to buy property already belonging to him. And the issue was whether the contract was valid. And the rule was that a contract is void where the buyer already owns property. And the application of the case was that the buyer was already the legal owner. So the court held that the contract was void, it was invalid, it was a nullity. Now, the second type of mistake is what we call a mutual mistake. Now, a mutual mistake occurs when parties misunderstand each other or they speak at cross purposes, so that no agreement arises due to the lack of consensus ad idem. In other words, there is no meeting of the minds, so that the effect of a mutual contract, a mutual mistake, is that it makes a contract void. It nullifies the contract. It makes it invalid from the beginning. And here we have the case of Raffles versus Wicholos. And the facts of this case were that a contract involved cotton shipped on a ship called Peerless. Now, two ships had the same name. The buyer meant the October ship, but the seller meant the December ship. So the buyer refused delivery. And the issue in this case was whether there was a valid contract. And the rule was that a contract is void if parties misunderstand the subject matter, or they speak at cross purposes, or where there is lack of consensus ad idem, or the lack of a meeting of the minds. And the application of this case was that each party referred to a different ship. So the court held that the contract was void, it was a nullity, it was invalid because of mutual mistake. But it's important for us to note that not every misunderstanding constitutes a mutual mistake. It can also depend on what a reasonable person will deem the circumstances to be. In other words, there are instances where the courts apply the test of a reasonable man, which is the objective test. The third mistake is what we call a unilateral mistake. Now, a unilateral mistake occurs where only one party is mistaken. Now, usually, a unilateral mistake does not affect a contract. But there are exceptions, and there are two exceptions. The first exception is where you have mistake about identity, and the second exception is where you have mistake about the document signed. So I want us to look at a unilateral mistake as to identity. Now, a unilateral mistake as to identity occurs when a fraudster pretends to be another person. So this can make the contract void. It can make it a nullity. It can make it invalid. Now, to establish that a contract was void, the party must prove a number of things. The first thing the party must prove, it has to prove that it dealt with a person other than the person it intended to deal with. Secondly, the party must establish that the person it dealt with was aware of that fact. And number three, the party must prove that the identity of the person or the party it intended to deal with was fundamental to the contract. And here we have the case of Candy versus Lindsay. And the facts of this case were that a fraudster pretended to be non-company. So the seller sent goods on credit to the fraudster. And this fraudster sold the goods to an innocent third party, and this third party was all candy. So the issue in this case was whether the seller could recover the goods. And the rule is that a contract is void if the identity of the person or the party one intended to deal with was fundamental to the contract. So the application of this case was that the seller intended to deal with different company. So the court held that the contract was void and the seller was able to recover his goods. A similar holding was made in the case of Ingram versus Little. And the facts of this case were that a fraudster bought a car using a fake identity. Now, the seller's confirmed identity before sale. The check by the fraudster later bounced, and the fraudster sold the car to a third party. And the issue was whether the seller could recover the car. And the rule is that a contract is void if identity mistaken is verified before sale. And the application of this case was that the seller relied on false identity confirmation, and the court held that the contract was void, and so the car was returned to the seller. Now, this decision in Ingram versus Little contrasts with that in the case of Phillips versus Brooks. Now, I want you to check out this case of Phillips versus Brooks. And the facts of this case were that a fraudster bought a ring using false identity. Now, the seller checked the address directory. Now, the check by the fraudster bounced, and the fraudster pledged the ring to a third party for a loan. And the issue was whether the seller could recover the ring. And the rule was that in face-to-face transactions, there is a presumption that the seller intended to deal with the person present. The application of this case was that the seller intended to deal with the person physically present. So the court held that the contract was valid and the seller could not recover the ring. If you look at the Kenyan case of Sebastian Jange Maria versus Now Mungania, the facts of this case were that the seller intended to transfer a land parcel number 267, but mistakenly transferred parcel 298 instead. So the issue in this case was whether the contract was void for mistake. And the rule was that the mistake at transfer stage may allow for rectification. And the application of this case was that the agreement clearly referred to parcel number 267. So mistake occurred during the transfer stage. So the court held that the rectification was possible through the land register. Now, the next mistake is mistake as to document sign. And this usually occurs when a person signs a wrong document unknowingly. Now, the effect of this is that it makes a contract voidable. Now, remember, a voidable contract is valid at the option of the innocent party. In other words, the innocent party can cancel it. Now, to avoid the contract, the party must prove a number of things. The first thing a party must prove is that the document fundamentally was different from the one the party thought it was signing. And secondly, the party must prove that they were not careless, they were not negligent when they signed the document. So that by proving this fact, the party establishes the plea of non est factum, which literally means this is not my deed. Now, unless these facts are proved, the contract cannot be avoided, as was in the case of Saunders versus Anglia Building Society. Now, the facts of this case were that a woman signed a document believing it was a gift transfer. Actually, she signed a mortgage document. Now, the loan was later defaulted by the nephew who lied to this woman. So the bank sought to possess her house. And the issue in this case was whether the contract could be avoided by the woman. And the rule was that one cannot rely on non est factum. In other words, this is not my deed if they are careless or if they are negligent. So in this case, the lady was careless and negligent when she signed the document. So the application of this case was that she signed the document without reading it carefully. So the court held that the contract was binding. So this lady lost the case and the bank possessed her house. The last type of mistake is mistake as to quality of subject matter. Now, this type of mistake occurs when a party is mistaken about the quality of goods. Now, the general rule is that this mistake does not make a contract void. In other words, it can't make a contract invalid or a nullity. And the reason for that is because of the doctrine of caveat emptor, which simply means buyer beware. So the law requires that buyers must inspect goods before purchase. So that if you don't inspect goods before purchase, you cannot come later on to claim that you are deceived or you are mistaken for that matter. So that is all I have as far as mistake is concerned. In our next lesson, we are going to talk about duress. If it is your first time here, make sure you subscribe to this channel and you watch out for the next legal lessons.